Center for tonight's debate. This microphone keeps slipping down on me. So let me just tighten that up. Just before we get started, some thanks are in order. First, thanks to our two debaters, who I'll introduce here in just a moment. Thanks to the Center for Inquiry for organizing and hosting this event, and thanks as well for inviting me to moderate. My name is Chris Walker. I host the morning show on CBC Radio here in Kelowna. We broadcast throughout the southern interior. I want to just very briefly share my experience with the larger debate about assisted suicide. In 1990, my grandfather died of ALS, or Lou Gehrig's disease. And then in my younger days, I worked as a legal assistant to lawyer Chris Considine, who represented Sue Rodriguez in her Supreme Court challenge. So you might think that I have a certain perspective, but my mother's side, staunch Catholic. So that makes me conflicted, but luckily as a journalist, I get to be professionally conflicted. And so here I am. And while we may not all have personal experiences, family or friends who have faced this choice, it touches us all in some way. That's why we're all here tonight. It is, of course, one of the most agonizing questions of our time. It touches on some of the most fundamental aspects of what it means to be human, what it means to have free will, and how death fits into our life. The question we're debating tonight is the following. Should assisted suicide be legal in Canada? This is a formal debate, and here's the format that everybody has agreed upon. Each speaker will have a 20-minute opening statement, followed by a 10-minute rebuttal and a 5-minute summation. We will then have 30 minutes for audience questions, and we'll be addressing questions to each speaker in alternating fashion. And I'll talk a little bit more about how the question period will work. I'll get my exercise tonight. I'll have a wireless microphone, and I'll run up to see you. So let's introduce our two speakers tonight, our two debaters. Margaret Dore is a lawyer in Washington State, where assisted suicide is legal. She's also the president of Choice is an Illusion. It's a non-profit corporation opposed to assisted suicide and euthanasia. Ms. Dore has been licensed to practice law since 1986. Her practice is focused on elder law and appeals. She is a former law clerk to the Washington State Supreme Court. She has several published court cases and many published scholarly articles. Ms. Dore's viewpoint is that people should be in control of their own fates, but that assisted suicide laws do not deliver. Last week, she had an editorial published in the New York Times, Assisted Suicide, a Recipe for Elder Abuse. Wanda Morris is the executive director of Dying with Dignity Canada. It's a charitable organization established in 1982 to educate the public about end-of-life options and the importance of advanced care planning, to provide information and resources to the public and lawmakers about the choice in dying movement and the reasons why approximately regulated and medically assisted dying should be legalized in Canada, and to provide support for individuals at the end of their lives, including support at the bedside for those who wish to determine the nature and the timing of their dying. So once again, two 20-minute opening statements followed by a 10-minute rebuttal and a 5-minute summation. Let's get to it. Who's first? Ms. Dore. Before I turn the microphone over, please turn your cell phones to vibrate or off. Thanks.
Hi, can you hear me? Or is this... We have to talk. Okay, my name is Margaret Dore. You heard that. I'm an attorney in Washington State, where, can people hear me? Assisted suicide is legal. Tonight, I'm going to be talking about the Oregon and Washington laws and how they work and how they relate to what's going on in Canada now. There's two court cases pending in Canada, which you may know. One is the Carter case here in BC, and the other is the LeBlanc case in Quebec. So before I get started, I want to make sure that everyone knows that I prepared a debate fact check handout. If you didn't get it, there should be still enough out on the table. And so I will be making some factual assertions. I'll say, well, this is how it is in Washington. And some of the things that I'll be saying, I'm supporting with actual article or something that you can look up yourself. So that's something you should be aware of. I also would like you to be aware of my website, or our organization's website, and that's Choice is Illusion, www.choiceillusion.org. It has links to the Oregon statutes, the Washington statute, the official reports, there's a lot of material there. You kind of have to weave through it. It's also linked to another website that is specifically Canadian, and that is called Euthanasia Prevention Coalition BC. So that's www.epc.bc.ca. Okay, so tonight we're going to have, I would say, a stark contrast. I agree with Ms. Morris that it's my life, it's my death, and I want to be in control of that. But I also don't want, well, I don't think from reading the laws, I disagree that the assisted suicide laws deliver. What they do is they protect the people left behind, doctors, family members, and other people. They're arrested for elder abuse. They also, if it's legalized here, you may find a loss of choice in your health care. But to give you an idea of where I'm coming from, I'm a lawyer, and Washington State, my former clients, they're my friends, own an adult family home, which I don't know if you use that term, but it's like a small nursing home maybe. It's in their home they have elderly people that need to be taken care of, not all elderly. So anyway, our law was passed by election, and that was in 2008. So 4 days after the election, the adult son shows up, wanting to know how to get them pills. It was not Dad saying, I want to exercise my right to die. Oh, isn't it wonderful this law passed? I mean, he was eating breakfast or something. So Washington's law was not yet in effect. So he didn't die, the gentleman did not die from a lethal dose. But what I want you to think about tonight, when we talk about choice, in real life, the way real people act with a real law, whose choice will it be? Will it be the adult son? Or will it be the old guy? Or you? Or your family? Okay, so in Washington, it's now been 3 years, or about 3 years that our law has been in effect. And we're already, in the newspaper, we're already starting to have discussions about expanding our law to direct euthanasia for non-terminal people. Right now, as I'll explain more later, our law applies to people predicted to have 6 months to live. And then, just a month ago, there was a column in the Seattle Times, and there's a link to it if you want to look it up yourself on my handout. And anyway, Jerry Large in the Seattle Times did a column talking about a column he'd done the week before, or a few days before, about how to pay for long-term care. And he was kind of going through his mailbag, and he was saying, well, most people were, sympathetic, but a few weren't. And he said more than a couple were sympathetic to people that couldn't afford to pay for their own care. And then the quote was, more than a couple of people, of readers, wrote in suggesting euthanasia as a solution for people that couldn't pay for their own care. So then now we're throwing in the idea in the public discussion of involuntary euthanasia. Now, of course, talking about something doesn't mean it will be passed, but I wasn't aware of anything like this for, say, 5 years ago, of anyone speaking about this, especially so nonchalantly. So that's been a change in our law, in our situation in Washington State. I would also like to read something from Juan, he's my friend who owns the adult family home, about how he's seen things change in Washington State. And this is from a letter that he submitted to a Montana medical board, actually in Montana. They're having a dispute there about assisted suicide. He says, since the act passed, he and his wife, have also noticed that some members of the medical profession are quick to bring out the morphine to begin comfort care without considering treatment. Sometimes they do this on their own without telling the client and or the family member in charge of the client's care. So once again, we're having kind of this theme of a little bit of involuntary, or the doctor just making the decision, whether it's the right decision or the wrong decision, the doctor just going ahead and making the decision. He also says, since our law was passed, I have observed that some medical professionals are quick to write off older people as having no quality of life, whereas in years past, most of the professionals we dealt with found joy in caring for them. Our clients reciprocated with joy and respect. Finally, he says, Someday, too, we will be old. I personally want to be cared for and have my choices respected. I, for one, am quite uncomfortable with these developments. Don't make our mistake. Okay, so now I'm going to focus on the Oregon and Washington laws and how they work. And as I go along, I'll compare Canada. After that, if I still haven't run out of my 20 minutes, I'll address some of the softer topics, which would be how assisted suicide being legal has affected healthcare in Oregon, and also an apparent suicide contagion in Oregon. Okay, so I'm going to have 5 questions. How did Oregon and Washington pass their laws? Who do these laws apply to? How do these laws work? I'll talk about Canadian cases and why assisted suicide laws are the way they are. So as I already said, our law got passed by election. That was in 2008, went into effect in 2009. Oregon's law was passed in 1997. Both laws were passed by ballot initiatives, which I understand you don't have in Canada. It's kind of like a referendum. They have an election and they vote on a question. Should we pass this statute, yes or no? And in Washington, we were targeted, and a lot of money came in from out of state and also out of the country to finance very well done ads that were kind of misleading. Well, they were misleading about what the law actually says and does. That it was promoted as only the patient can take the lethal dose. Well, I've read the law. It doesn't say that anywhere. And there are other problems with it as well in terms of if it's going to be the patient's choice, their autonomy, well, then they should at least have, they at least have what it says. In any case, the problems with the bill did not come out, and we lost. Okay, contrast that to what's happened in the U.S. legislatures. There have been more than 100 proposals to pass similar laws in the U.S. They've all failed. In Canada, 2010, 2 years ago, about 2 years ago this time, your parliament defeated a law that would have legalized assisted suicide and euthanasia. That was after a year of discussion. It was 228 to 59. Many people who think they're for this, and I saw this in New Hampshire when I went to testify there, many liberal people thought they were for it until they started talking about it with real life and how would it work. And they started seeing some flaws in it, and the more they tried to amend the flaws, they started to see that if they're going to protect people, they couldn't amend it. And actually, it was the Democrats, the liberals, that made the motion to dump the bill, and it was about a 2-to-1 vote, similar to your parliament. So, who do the Washington and Oregon laws apply to? As I said, it's 6 months to live. But that's what the prediction is. People aren't necessarily dying. So that's because doctors can be wrong. I mean, life expectancy is based on a statistical average. Some people will be below and some people will be above. And one of the handouts on the table, if you didn't pick it up, is called Terminal Uncertainty. And it gives a nice overview of different people who live quite a bit longer than they were expected to, and also who had a good time. The featured person that was given, I don't remember now, 2 months to live or something. Anyways, 4 years later, she's going on all these vacations with her kids. And there's a quote from her son that says something like, we almost lost her to having too much fun, not from cancer. Now, more specific to this discussion is my friend, Jeanette Hall. She's now my friend. I met her because of this issue. She was diagnosed with the same cancer that killed Farrah Fawcett, and she voted for Oregon's law, and she didn't want to suffer, and she wanted her choice, and she'd been given 6 months to a year to live, so she didn't quite qualify for the Oregon Act yet. And so she went to her doctor to find out how to do it, and then she went like 3 or 4 times, and every time she'd leave, and she's like, well, I still don't know how to do it. And what he was doing, he was stalling her because she happened to go to a doctor who didn't believe in assisted suicide. And he also thought her cancer was very treatable. And he convinced her to be treated, and that was 12 years ago. And she's still alive today. And she's published, one of her letters to the editor is listed in my, she's published a lot of letters to the editor, including in Canada, about her experience. And one of them is in that fact sheet if you want to look at it yourself. So my point, even with a restricted law, like Washington and Oregon, we are not talking about people who are necessarily dying anytime soon. And they may, for some people, these laws encourage them to throw away what could be, very interesting times yet ahead. So how do the laws work? That's my second topic. There's two parts. First, there's the application part. And this has a form, and you can go to my website and link to the forms. You can see them. Well, I link to the official sites, so you can see them on the official sites. And there's waiting periods, and there's some safeguards. But once the lethal dose is issued by the pharmacy, there's no oversight. The death can occur in private. There can be just two people there, and one leaves alive. No witnesses are required. So, I gave this example last night, not to bore Wanda, but, think of, so say there's an older gentleman, he's been given the terminal diagnosis, he's thinking he doesn't really know, do I want to try to be treated, do I want to do this, do I want to do that, and, son says, well, I'd hate to see you suffer. Why don't you get the lethal dose just in case? I think, you'll have your choice. Okay, that sounds good, all right. So he gets the lethal dose, and then, say this a little time's gone by, a month or so, and they're watching TV, and it's the latest disaster. Say in the States, those tornadoes are just awful. And so Dad says something like, I think I'll give half my money to the Red Cross. I think that would be a good legacy for me. Next day, Dad is dead. Okay? So even if you struggle, who would know? And actually, just by getting the lethal dose, you just put a sign on your head that says if something happens, if I die suddenly, don't ask any questions. Now, in one debate I did, the other side pointed out that the lethal dose is often given in pill form, and they said, well, how would you give it to someone without their consent? Well, Seconal, and the other one I don't pronounce very well, Nembutal, they're both water and alcohol soluble. You simply, you could inject them while someone's sleeping. Say if they've had a nice stiff whiskey, sleeping pill. Not very nice, but it wouldn't necessarily be with their consent. Okay, so the Canadian cases, LeBlanc and Carter, and just for the record, they're not limited to assisted suicide. It is euthanasia and assisted suicide, and actually with very broad terms. But in any case, just to focus on the topic tonight, which is assisted suicide, these proposals also envision a death in private. There can be two people. One would be the patient, and one would be a person acting under the general supervision of a doctor. Well, who acts under the general supervision of a doctor? Well, family members. We've all done it, or maybe you haven't all done it, but I've done it. You help someone with their medication, or you help them with the device, or whatever it is. So that would be a family member, and the typically older, well, in Oregon and Washington, typically older person. I don't know if that's true with your law, or your proposed law. But once again, even if the person struggled, who would know? How is their choice guaranteed? So when I first started working on this, I kind of got into it because I'm a probate lawyer, and I looked at, you give me flavor when I have 5 minutes, so I don't just ramble on. I'm a probate lawyer, and in a will in Washington State, if you have one of two witnesses, if a witness to the will is going to benefit from the will, and they participate in writing the will, that creates a presumption of fraud, coercion, and undue influence. You can set aside the will. Canadian law may be similar, because your law is similar to ours. We're from the same place. Okay, but under our Death with Dignity Act, that's okay. That's specifically okay. And I saw that, I'm like, you can't have a law like that where your heir can be taking you in and signing you up, helping sign you up. And there's another provision that says that, someone else can talk for you. It's part of the definition of competent. So that got me a little alarmed, and then I saw there was no witness, and so I didn't know if I was really against assisted suicide yet, but I knew I was against the bill. And it puzzled me, why would the bill be like that? You know, why would anybody make a law like that? But really, what is the purpose of the law? Right now, it's not, I mean, these laws are not going to change. It's not illegal to commit suicide. People are entitled typically to suicide prevention. But it's not illegal to commit suicide. What is illegal, except where I live in Oregon, it's illegal for somebody else to help them by encouraging them or counseling them or actually giving them the lethal dose or injecting them. That is illegal. So the operative things these laws do, the change in the law will be that other people can kill you or your family member or help kill them in the case of assisted suicide, facilitated suicide, and not get into trouble. So that's what this is about. Otherwise, the doctor or anyone else could be sued for malpractice, they could be prosecuted, they could, if nothing else, have a very upset family member stalking them for years, you know, or something. So the way the Washington law works to protect doctors and protect other people, it gives them express immunity from prosecution, from professional discipline, and from being sued. The death certificate is required to list a disease, so that, say in my example, a good sister comes home and, you know, is told that dad has died, and, well, how did he die? I thought he seemed okay. Well, here's the death certificate. It shows a disease, so she won't even know. So that's another, there's multiple layers of protection. The more you read the act, the more you see. Now in Canada, what they're proposing, here in Canada, they're proposing making a constitutional right for the assisters to be assisted. I personally would not want somebody else to have a constitutional right to cause my death. And I don't see how, you know, that's ramping it up from Washington. Getting back to my example, the son also would typically, someone who was a slayer would lose their inheritance if it was proved that they participated in the death. But under our law, you're protected from that as well. So already elder abuse is a problem in both the U.S. and Canada, and so this will give another path to elder abuse. It's already very hard to stop because it takes place behind closed doors. The older person is often embarrassed or has many reasons not to let anybody know. You don't want to air the dirty laundry. So anyway, I've got 1 minute? 3 minutes. Okay. So that was what I'm talking about the law. So I want to talk a little bit about healthcare in Oregon, and this is specifically mentioned in the handout, the fact check handout. But I think this happened in Washington too. But what happened was in Oregon, right around the time of our election in 2008, there was a woman named Barbara Wagner and also a guy named Randy Stroop. And they got their health care paid for by the state-run health plan for people that were indigent. And they got turned down for treatment and offered assisted suicide instead. So plans do turn people down for treatment. I mean, that happens. It's not nice, but I mean, that's just life. But to also be told that you can go to be encouraged by the state, by the government, to go kill yourself, that's steerage. So by having these laws in place, the government gets more involved in your life and can be steering citizens to suicide. So anyway, I think I have a minute. Okay, I'll just, in closing for my first part of here, I just want to emphasize we're not talking about people who are necessarily dying, and this is true even under Oregon and Washington's acts. You heard about my friend Jeanette Hall. I agree with Ms. Morris that people should have choice. I want choice. That's why I want our law gone from Washington State. I'm very alarmed that Canada could legalize assisted suicide. And in Oregon, we have documented cases of the state health plan steering people to suicide. Don't make Washington, Oregon's mistake. Thank you very much.
Good evening. Good evening.
And thank you for having me. I represent an organization called Dying with Dignity. And for 30 years, we have been working to improve the quality of dying for Canadians. Our first executive director, one of our founders, was a nurse by the name of Marilyn Sedgwick. And she got involved with the organization because she had been at the bedside of many people who had a horrific death. And she really believed that there had to be a better choice. She started a program that we still run to this day. We call it our client support program now. And for individuals who are suffering terribly at end of life and want a different option, want to hasten their dying, we provide them, in the context of lots of checks and balances, we provide them with support to end their lives, information, and we can be with them at the time. Do I need to do that whole thing again? Okay. So our organization runs a client support program. We companion people at end of life who have a medically diagnosed terminal illness or incurable progressive physical illness. We give them information about peaceful ways to die, and we, if they choose, we can be with them at end of life. That shouldn't be our role. Individuals who are suffering grievously at end of life and want to determine the nature and timing of their dying should have assistance. It should be the last act of our compassionate healthcare system. Margaret talked about what we do as killing, as in we shouldn't kill people. Killing is not what we do. If a man goes in and robs a bank, and the robbery goes horribly awry, and he shoots a police officer and she dies on the way to the hospital, that is killing. If an estranged husband breaks back into his house, stabs his wife and children, and they die, that is killing. And if a son decides that he can't wait any longer for his inheritance, and he pops some poison into Pa's porridge, that too is killing. Killing is abhorrent, killing is wrong, killing is reprehensible. It is not what we are about. We believe that there is some suffering that only death can end. Take the case of Leslie LaForest. She is a woman who provided testimony in the recent Carter case. She is a woman who has so much to live for. She's looking forward to seeing her daughter graduate from university. And she is a woman with anal cancer. Her doctors are recommending a surgery. The side effects are that she will likely end up incontinent and with diarrhea. The surgery will result in scarring to her vagina that will make intercourse extremely painful and even urination to be discomfortable. Yet if she doesn't have the surgery, the tumor that is beside her bowel will grow and grow until her bowel kinks over, and the poisons in her body will have no way to escape, and the toxins, and her legs will swell and swell, and eventually fecal matter will ooze out of every orifice. This isn't a woman who wants to die, but given what her disease is giving her, she would rather have a choice. We have members right across the country, individuals who support the right of choice, who believe in the principle of autonomy. And many of them have been moved to join because of an experience of a horrific death of a loved one or family member. And one such person is Meg Westley, our board president. At 75, Meg's mom had a mastectomy. But unfortunately, the operation didn't stop the cancer, and it metastasized. It went into her bones and into her brain. Because of the chemotherapy, she was bald. The brain tumor caused her to be blind in one eye, and she had a disfiguring hump on her back. She was bedridden, and because of a severe reaction to the painkillers, which was acute nausea, she was unable to control her pain. And so she suffered terribly for the better part of a year, always asking why she wasn't dead yet, why she had to keep suffering. Eventually, she stopped eating and drinking and starved and dehydrated herself to death, but even that process took 10 days, even though she was only 90 pounds at the time. And then, of course, those of us lucky enough to live in Kelowna know that we're next door to Gloria Taylor, a woman who's marching in the heroic steps of Sue Rodriguez. In 1993, Sue Rodriguez went to the Supreme Court of Canada and she asked, "Who owns my body?" She was fighting for the right to die because she had ALS. And now we have Gloria Taylor who's doing the same thing. ALS is a very cruel disease. It attacks the muscles of the body and they gradually atrophy. First, an individual can scratch an itch at the back of their neck and then lose the ability to feed themselves. They might have gone to the doctor because they noticed that suddenly they were tripping or they couldn't hold objects in their hand properly. They got a pretty horrific prognosis. They would find that first they'd be walking with a cane and then a walker. And then at some point they'd be in a wheelchair. And then even the most sophisticated breath-controlled wheelchair would no longer be sufficient to hold them. And they'd end up bedridden. And there they would lie until the muscles in their lungs grew so weak that they would suffocate no matter how much oxygen was in the room. For Sue Rodriguez, for Gloria Taylor, and for others with ALS, is it any wonder that they want a different choice? These are not people that want to die. These are people that love life. But given that they know their death is inevitable, they would like the control, the opportunity for a peaceful and humane death. For these individuals, for Meg Wesley's mom, for Leslie LaForest, their quality of life, or their foreseeable quality of life, can be so bad that life is no longer a benefit. They believe that they are better off dead, that death is the benefit, and they want compassionate medical assistance to help them achieve it. So what is the difference between killing people and providing medically assisted dying? The difference comes down to choice. In Canada, we are so fortunate to have so many choices. I've had choices all my life. The choice to go to university, to get married and have a child, to have a career and then have a completely different one. We get to choose where we live and who we vote for. So why is it that at the end of the life, when we're facing one of our most critical choices, when we want the opportunity to choose the nature and timing of our death, that choice is taken away, that we lack control, and that the government says they know better than us, and we shouldn't have that choice? Yet choice, autonomy, these are cornerstones of modern medicine. There isn't a diagnostic test, there isn't a procedure, there isn't an examination that can be done to me without my informed consent. This is a principle that was established in the early 90s in Quebec in the case of Nancy B. She was a young woman who was suffering at end of life, and her doctors wanted to perform some procedures. She didn't want them, and the doctors were insisting. She continued to decline, and the matter went to the courts. And the judge decided that she had the right to refuse treatment, even if such refusal meant the end of her life. It's ironic that if Gloria Taylor was on dialysis, or artificial nutrition, or perhaps insulin, that she would be able to stop those treatments and end her life. But because she's not dependent on any medical technology, she doesn't have the choice. Imagine that you are a farmer, and for years you've been battling cancer. And the cancer has progressed to a point that every step is painful. Every breath hurts. and you've decided that you don't want to see this disease through to the end. And so you take your shotgun and you go out to the back of your property behind the barn. And you put the gun to your head and you pull the trigger. And inside the farmhouse, your wife and your son hear the shot. And your son volunteers to be the one to go out to find you. And that's his last memory of you, with your body more or less in one piece, but your head in a few different bits. In the early 70s, we legalized the right for Canadians to end their lives, but we've taken away the peaceful and humane ways for that to happen. So not only do people who are dying face the prospect of an unbearable death without relief, but sometimes the violent means they resort to can traumatize family members and loved ones that survive them. We need to offer meaningful choice. We need to offer medically assisted dying. And what I mean by that is two different terms. One is called physician-assisted suicide, and this is where an individual is able to get a prescription for medication that they can take themselves. And the medication will allow them to have a peaceful death. The other is called euthanasia, and this is where the medication is not only provided, but it's administered either by a doctor or by somebody under medical supervision. When Sue Rodriguez took her case to the Supreme Court in 1993, the ruling came down in 1994, and it was the 9-member Supreme Court was split 5-4, so it was a very close decision. And Justice Sapinka, writing for the majority, said, Sue's case was, she asked the question, who owns my body? And she said, since the 70s, Canadians have had the right to end their lives, but I'm disabled. I can't physically take medication and swallow it, so I don't have that right. And therefore, I'm being discriminated against because of my disability. And Justice Sapinka, in writing for the majority, agreed with her, agreed that her charter rights were being violated. But he said, we need to do that in order to protect the weak and vulnerable in Canada. And furthermore, nowhere else in the Western world is choice in dying, assisted suicide, legal. So very much has changed since that time. We now have 5 jurisdictions that have legalized choice in dying, 2 through ballot initiatives, the first being Oregon in 1997, and then 3 through changes in the legislature, the Netherlands, Belgium, and Luxembourg, with Washington State 5 altogether that have written legislation to allow for choice in dying. Now, this legislation doesn't allow you to walk into a doctor's office at 2 o'clock and be finished by 5 in the afternoon. There are a whole series of checks and balances. Margaret mentioned the idea of the son saying, I'm going to go get some pills for my dad. That is not how the legislation works. It is first and foremost for, if we look at the Oregon legislation, it is mentally competent adults. So an individual must be an adult and they must be able to understand their decisions and make their own decisions. Nobody else can make the decision for the patient. They make their own decision. And then once they have broached the subject with their doctor, they must do so repeatedly. They must do so again in writing within 15 days and then again orally. The doctor in Oregon, the eligibility requirement is that somebody be at end of life, which they define as having a terminal illness, 6 months or less to live. So the doctor must provide a diagnosis of terminal illness, and a second independent physician must occur. There must be witnesses to the statement. Margaret is concerned that the witnesses would be family members, but who else would likely witness but our closest loved ones? Yet there is another layer of check and balance because the individual provides a statement indicating why they want to end their suffering. And so with that and the interviews, any evidence of coercion would be followed up and the request would be denied. And what we know is that the requests are often denied. For example, in the Netherlands, over 2/3 of requests for assistance to die are never fulfilled. There are indeed checks and balances in place. Now, since the legislation has been written, it's been some of the most studied legislation ever written. Margaret Paus-Batten is a researcher out of the University of Utah, and she looked at the individuals who used the legislation, both in Oregon and in the Netherlands, to see, is there evidence that there are weak and vulnerable people using this legislation? And what she found was that there was one group, which was gay men, who were overrepresented. And if we think of the AIDS epidemic, that's probably not surprising. But otherwise, what she noted is the most likely users were men, white men, who were well-educated, and probably because they're well-educated, they also were reasonably well-off. So not a group that we typically think of as being the weak and vulnerable in our society. As part of my role, I get to speak across Canada. I talk about the importance of advanced care planning and all about end-of-life options. And so very often when I speak, there's one person waiting to talk to me at the end of the lecture. And when everyone else is gone, and the two of us are alone, they share their story. And sometimes they're sharing it for the first time. They tell me about a sister or a mother or a daughter who was suffering terribly at end of life and begged them for assistance. And they tell me how they helped, how they ordered the medication or held out the cup so that their loved one could drink its contents through a straw. Or even the situation where the medication didn't work and they granted their loved one's dying wish and held a pillow to suffocate them. And the stories can be years or decades old, but the pain still lingers as they wonder if they made the right choice, yet can't understand how they possibly could have lived with themselves by making another. And perhaps even worse are the stories of the men, the husbands, the fathers, the sons, who talk to me with tears streaming down their faces about how they didn't help, how they turned away and either were unwilling or unable to assist, and the guilt that still haunts them to this day because of the suffering that ensued. We need to offer a choice to competent adults at end of life who are grievously ill and suffering unbearably. It is the last act of a compassionate society. We need to offer a peaceful, a humane, and a gentle death. Thank
you. So we now have a 10-minute rebuttal from each.
Okay, I want to just address a couple of things, not in any particular order. First of all, informed consent can be given by another person. So Wanda brought up the issue of informed consent. It can be given by your power of attorney, it can be given by your spouse, it can be given by your children. And actually, in the Carter case, which is pending, if you read it, you'll see they talk about, that's called substitute decision making. The way I read it is the Carter case would allow substitute decision making. Your power of attorney could agree to it. That's what it seems to be saying. It's a little obscure, but that's what it looks like to me. Also, I didn't see that it was limited to adults. And I didn't see that it was limited to competent people, but that gets into the substitute decision making. So, but the court, what will actually happen in Carter, we don't know. There hasn't been a ruling yet. It could just be denial. I mean, it's the same as your Sue Rodriguez case. So they could just say, we're not going to do anything, keep the law the way it is. Or they could do something like Oregon. Most Canadian lawyers tell me they don't have the power to do that. In the US, they don't have the power to do that either, but a judge actually did that in Montana. It was later vacated. But you never know what a court will do. I wanted to talk about the idea of suicide in Oregon. The idea that a theme that Wanda had was that this will get rid of violent suicides. No. In fact, violent suicide is up in Oregon. They've had legal assisted suicide since 1997. By 2000, their suicide rate was, quote unquote, increasing significantly. And this is and I cite the Oregon studies in the handout that I made available for you. And this would be consistent with a suicide contagion. In other words, you normalized one type of suicide, so you implicitly encourage other suicides. Let's see. Okay, I've also had people that come up and talk to me after I talk, or they write me, about how there's a Canadian who wrote a very well-written, it's the highest hit document on my website. It's Kate Kelly talking about how her mother died. Kate, K-A-T-E, K-E-L-L-Y. And it destroyed her family. And anyway, her mother had a mild stroke. Her brother had power of attorney and authorized comfort care. Her mom was trying to talk and was indicating she wanted water. They cut off the food and water, and she didn't get her voluntary choice. She wanted to live. And anyway, it's a very moving story. Also, I wanted to characterize what I had said as talking about killing people. I think what I was saying was that it should be voluntary. And when you have these laws, what seems like would be a voluntary choice, you've just empowered somebody else to do it to you. So, I want it to be voluntary. Whatever happens to me in my life, I want it to be voluntary. And that's why I'm against our law. One thing that Wanda talked about the safeguards in Oregon and Washington. Notice she didn't say anything about what happens once the lethal dose is in the house. 2 people, one of them leaves dead, one of them leaves alive, one of them leaves dead. How do you do a study on that and find out what really happened? It's really hard to know what's happening behind closed doors. In Canada, there was Melissa Friedrich, I hope I pronounced her name correctly, the internet black widow, and she was from Newfoundland, but anyway, she was kind of famous. She was a DV victim, and so she ran over her husband, and she said she was defending herself because of all the abuse. But then by the time she'd killed the 3rd guy, they kind of figured out, well, maybe she wasn't a victim, but it's just really hard to know what goes on behind closed doors. But anyway, there is no oversight of the death in Washington and Oregon. Over administration of the lethal dose. Anything can happen and no one will know. So any study that says that the Oregon and Washington laws are safe is invalid because there's no oversight. Completely no oversight. Another thing, when you look at the most reported elder abuse, it's financial. That's true in Canada, and I believe that's true in the US as well. So who are the people that use the act the most? And Wanda was correct. They're older men, well-educated, and well-off. That's your typical victim of financial abuse. So that would be somebody maybe with a house, $100,000 in the bank, some savings. They've got something somebody else wants. So the Oregon statistics, such as they are consistent with elder abuse. Also, the Oregon statistics do not report on consent. That's just left off of the report. They don't ask the doctors whether the patient consented. Of course, the doctor doesn't know. The doctor's not usually there. And it's kind of like the don't ask, don't tell kind of report. So nothing about consent. And the way I read the act, consent isn't actually required. Another handout that's out in the hall you might want to look at is by Dr. Toffler. And he talks about I retitled it, it's a statement to the BBC, why do people say they want to die? And he talks about how he's turned down in Oregon maybe 10 people who said that they wanted to do the act. And he said one of the first guys was a man in a wheelchair, and he just simply responded, "Thank you." Sometimes when people say they want to die, they want you to tell them no. But okay, so last night I prepared a few things, some things to talk about. Let's see. Pain. There are some bad deaths. I'm not going to say they're not. Healthcare professionals tell me that most pain can be controlled. I was with a doctor last night who also watched Wanda's presentation, and she made the same examples, and he thought that they were, he used the word sensationalized. But there are bad deaths, and in a really bad situation, there's the extreme idea of terminal station. 3 minutes, okay? In other words, you put someone to sleep until they die. But of course, that can be abused. And actually, that's what I'm hearing anecdotally in Washington. Kate Kelly, that's what happened to her mother. In the US, we have an interesting case that was recently filed in California against Kaiser Healthcare. The daughters of a very wealthy man had said how he didn't want to suffer, and he never wanted to be on a ventilator, and anyway, they authorized his death. This is looks like a direct euthanasia to me. And it turned out that they didn't have authority to do it, so the son, who was against that, sued and said, actually, Dad did want to live, and he had 10 years to live. He had a very mild case. I think he had early Parkinson's. I forget the exact one. Anyway, so she's suing. But anyway, I won't say that all deaths are easy, but the issue is what happens if assisted suicide or euthanasia, but again, the topic tonight is assisted suicide, is legalized in Canada. How will that change things? Will you be the next Barbara Wagner? Will you be the next Randy Stroud? Also, it's hard to tell somebody's competent. I had a client come in one time, an older woman came in with her nephew, and they wanted a power of attorney, and I said, okay, and I talked to her, and she seemed fine. And then I needed to ask her something, so I called up where she lived, and they started saying, well, she has short-term memory loss. I'm like, she does? I missed it, right? And it turned out the nephew was taking her to the bank once a week, and because she could socially pass. She'd go in, take out $1,000, chit-chat, and come back and give it to him. And so she ended up being put under guardianship. Okay. Legal assisted suicide will allow the government into your life. And also, regarding the Barbara Wagner scenario, I can't do this in 1 minute. Maybe I'll just stop right there, because I feel tongue-tied.
It seems like we have the perfect setting for a murder mystery. We have controls all the way along the way. The individual makes multiple requests, including a written request as a capacity assessment, writes a written statement, is interviewed, doctor's diagnoses, they get their prescription, they have the 48-hour cooling off period, and then they get the medication. Now, I'm not sure if Margaret wants them put under armed guard after that point, but that is the way the legislation works in Oregon. If that is a flaw in their legislation, here in Canada we have another choice. We are starting with a clean slate, and we can write in any safeguards and any protections that we want. Yet, I suspect that Margaret and others that oppose choice at dying could not come up with a list of safeguards, of precautions that would satisfy them. Because I think they are opposed to choice on principle, and that nothing we could propose for safeguards would ever be enough. Margaret mentioned that in Washington State, there's already some discussion of expanding the law. Indeed, in the Carter case, The decision was made not to try to establish an arbitrary limit like 6 months, just because it's such a difficult thing to diagnose, but rather to go with definitions of unbearable suffering and grievous illnesses. Margaret mentioned that these laws encourage people to throw their lives away. Nothing could be further from the truth. Nobody says, "I've got a perfectly good leg, let's cut it off." In fact, one of the tragedies of our current laws is that because people who choose to hasten their dying must manage every aspect themselves, they often end up going months or even years before they might otherwise have to. What people who are facing the prospect of a horrific death really want is peace of mind. And one of the ways they get that is knowing that they have control over their choices. Not because they want to end their lives, but because if the worst comes to the worst, they want to know that they have a choice. Margaret has raised the specter of elder abuse. So I think let's just be really clear here about what we're talking about and what we're not talking about. We're talking about competent adults, individuals asking to make a decision, asking for choice on their own behalf. Nothing that is being proposed in the Carter case or elsewhere talks about giving other people the right to end our lives. It is all about us making the decision. And indeed, there are numerous safeguards that have been suggested to just ensure that no coercion is taking place, and this truly is a free choice. It's critical that we protect the weak and vulnerable in Canada and make sure nobody is coerced into dying at end of life. That is one group of individuals, and we need to look after their needs. There is another group of individuals over here, those individuals who are facing the prospect of a horrific death, who see no quality in their lives and want a peaceful way to go. And we need to respect their rights also. I think one thing that we can look at that's very compelling is the satisfaction levels of individuals in jurisdictions that have introduced choice in dying. There was one survey that was published comparing the satisfaction of individuals with their doctors in various countries in Europe and around the world. And the country with the highest level of satisfaction with their doctors, the greatest respect for their doctors, I believe is how it was phrased, was the Netherlands, at over 95%. We're not scared that our doctors are going to kill us. We're worried that if the worst comes to the worst, they won't be there for us, and they'll leave us to suffer alone. Margaret mentioned that most pain can be controlled, and indeed studies show that about 98% of the times palliative care can be effective in controlling symptoms. But when you look at 2% of people in palliative care every year, the numbers add up. And why should thousands of people suffer? What's more interesting is when we look at the statistics in Oregon in terms of who has chosen to use the death with dignity legislation, and over 90% of the people who have chosen the legislation have been in palliative care at the time. Palliative care is critical, it's an important part of quality dying, and it is simply not enough. Margaret mentioned that for people in extreme cases, we could offer terminal sedation. So we can put someone into a coma and cut off their food and drink and just allow them to die slowly. If we can do that, can we not just offer the humane, the gentle, and the peaceful choice of direct assistance to die? talked about the case of Randy Straub and Barbara Wagner, two individuals that were turned down, and she mentioned that they were steered towards suicide. Well, let's talk about what really happened with those two individuals. Randy Straub, some of you may be familiar with his case. He was profiled in How to Die in Oregon. He had asked for medication, and his request had been turned down, and he received a letter. And in that letter, he was told about all his options. Options for pain control, palliative care, and about the death with dignity legislation. Of course, in the context of the movie and other speakers that you might have heard, that's very sensationalized. It's as if they were told, no, you can't have the medication, you may as well go kill yourself. Subsequent to the making of that film and those cases, when individuals now are declined medication in Oregon, they're not told about the Death with Dignity Act. I think this infringes on their choices, but perhaps it's a victory for those who would like less choice. Choice is the foundation of modern medicine. We have choice in so many ways at so many times, and we need to have choice at the end of our lives. For competent adults with grievous suffering and incurable illnesses, mentally competent adults should have the right to ask for assisted dying if they choose. And as a humane society, we should offer them that option. Thank you.
And now I'll have a 5-minute summation.
Okay, so what I started to say, was that I wanted to talk a little bit more about Barbara Wagner and Randy Straub. And after the election, the head of Compassionate Choices, which is the big assisted suicide group in the U.S., did an editorial about Barbara Wagner. And I've got it, it's cited in some of my materials. In any case, she did a little blaming the victim. She said, well, Barbara Wagner was a smoker. And then she also talked about the public policy, that there should be a public policy to discourage people from getting cures, and argued against her individual choice. Now, you can validly make an argument that the drug she wanted was a I guess you call it a third-tier drug. It might not have worked. And I guess you can argue in a state health plan that that's a legitimate thing to do. But if you're leading an organization called Compassionate Choices and saying you're for individual choice, that's not what you're really about. So, you have to look at what people are doing. So a couple other things, just to go through. Jeanette Hall. Jeanette Hall was encouraged and steered to suicide. That's how her doctor characterizes Ken Stevens. His letters to the editor are in some of my materials. And he says the mere legalization steered her to suicide. She voted for it, and by gum, she was going to do it. And also, she had that horrible-sounding anal cancer. That's what Farrah Fawcett had. But she doesn't like me to say that because it's not ladylike. Let's see. I can't opt out of our law. Individuals are not allowed to opt out. We lose our right to contract. And again, that's because the doctors and the people left behind have to be protected, because that's what these laws do. Carter, you can read, there's an article that I passed out that's up there about the Carter case. I don't know how many copies I had. It's also on my website and on the Canadian website that I cited. And you can read the complaint yourself. There's quite a bit about substitute decision-making in there. And as far as the previously and irremediably ill, it's very broad. There was we would call it answer interrogatory. I think you call it a demand for particulars. I've seen it, but I didn't have time to really study it and bring it, but it's pretty wide open. So again, your Carter case is not Washington or Oregon. As far as trusting your doctor, legal assisted suicide can lead to lazy doctoring. It's just easier to give someone a lethal dose and send them on their way. But again, I think I'll just close with some of the points that I closed with before, which is to just go through it, that I agree with choice, and whether or not I have a principled disagreement with assisted suicide or not, it doesn't change what the laws say and how they will affect you. And so it should be your choice, and you should be informed that these laws are to protect doctors and the people left behind. That's why they're having the laws, because as Wanda pointed out, there is already, she called it a right to die, but the suicide's not illegal in Canada. That's already the case. So what is this lawsuit for? The lawsuit is to protect doctors and the people behind. What were our laws for? They're to provide immunity to doctors and people left behind. So again, even if it would be a limited thing like Washington, people aren't necessarily dying anyway, and I hope we all get our choice. Thank you very much.